Welcome, everyone. I am really pleased to be able to bring you what I hope is the first of several conversations in, well, our celebration, but maybe not yours, our celebration of the impending publication of the fourth edition of course, we're the author, so we think it's a marvelous casebook, Ravitch and Baker's Law and Religion, cases and materials. It used to be cases and materials and readings, but now it's cases and materials. And in celebration of that event, what we thought would be fun would be to choose a number of key cases, starting with cases that are hot off the press, and maybe spend a couple minutes talking about them. And for today's discussion, we are going to look at probably one of the most significant cases, even if it is, and we'll argue about this, whether it's a doorway case or whether it's actually significant in and of itself. Fulton versus City of Philadelphia, which was just recently decided, I think on the 17th, the opinion came down. And it's a very interesting case, especially because it was meant to be a case that was through which what is now a generation-long ideological battle over the foundations of, I'm going to shock Frank in a minute, the ideological basis of the Reynolds case as transmogrified into the Smith decision of Justice Scalia would finally fall. And to a large extent, Fulton represents I think from my perspective, the current iteration of what at the time had been the United States' first engagement with a kind of a homegrown but a foreign religion, that is the Latter-day Saints, the LDS religion, and then incorporating it in. And now, of course, metastasized into the enormous number of both old faiths and new arriving faiths in this country. But anyway, so that's what we're going to talk about. We'll see where this gets us. And I'll start, Frank. Tell me about the context of Fulton versus Philadelphia, and what do you think?
Well, what's going on in the background in Fulton is that the Catholic Social Services, which had long been serving as a foster care agency through the city of Philadelphia, were essentially denied the ability to continue serving in the foster care capacity because, of course, they refused to recognize same-sex couples. They agreed that they would refer any couples in that situation to one of the other agencies. There were 27 other agencies in the city, but that they would not serve themselves. So the city said this violates the city's anti-discrimination provisions.
So they actually offered an accommodation, in a sense, before the litigation, and an accommodation that was rejected by the city.
Yeah, in a sense they did. I mean, what they said is, look, we will refer. We're not going to say no to these parents. And then tell them they can't go anywhere. At the very least, they said they would refer them to the city for another referral, or they would refer them to one of the other. If you follow Justice Alito's argument, they would refer them to one of the other 27 agencies in the city. At the very least, they said they would, refer them back to the city. But this was this was a conflict. I've written a lot about, but in this case, I think it's a less, the city's argument is a bit less compelling than, say, for example, the plaintiffs in the Hobby Lobby case arguments. We'll talk about that in a little bit. Because here, Catholic Social Services was one of 28 agencies that served, and I think the city's argument would have been much stronger if there was two agencies or only Catholic Social Services, right? Because then the only agency available discriminates, right? But the underlying question of whether even a religious entity can follow its traditions in a way that is argued by the city to discriminate, and certainly, from a non-religious perspective, does discriminate. So the question is, what's this balance? And that's really what's going on behind this case.
Okay. So is what everyone assumed, or at least the people who view Supreme Court cases as judicial legislation, and that's a bone that I will pick in a different discussion with you.
I'm not sure I completely disagree with that. I think that in some ways it's only a question of whether it's openly acknowledged judicial legislation sometimes.
That's right. So they wanted to get rid of the law of Smith and ultimately attack its very thick roots, again, going back to Reynolds, and that this was going to be the case where it is possible. So assessment, in this case, of course, in a very, very carefully crafted decision, one that was almost oracular in a lot of ways and quite precise. Justice Roberts, I think, Chief Justice Roberts, sort of appeared to sidestep Smith, but also fault the city for their policies and void the policy. Given all of that, do you think that Smith is either dying, mortally wounded, or does this effectively overturn it?
This case does not overturn Smith, but I think it does at least show the future alignment that very likely would overturn it. Essentially, you've clearly got three dissenting justices who would overturn it, right? Alito, Thomas, and Gorsuch clearly support overturning Smith now. We know that there's a concurring opinion by Justice Coney Barrett, and we know that in that concurring opinion, Justices Kavanaugh and Roberts, Breyer, who joined in that opinion, both have suggested they would support overturning Smith at various times. Coney Barrett seems a little more on the fence about it, but her big question wasn't, should we overturn Smith? It was, if we do that at an appropriate time, what do we replace it with? Do we use the compelling interest test? What do we do if we overturn Smith? So it's hard to read if she's saying, yes, we should overturn it. Remember, she's a big fan of Scalia. But I get the impression that in an appropriate time, she would be willing to overturn it. Roberts, I think, would be willing to overturn it. Yeah. So really, I would argue that without Hobby Lobby, and we'll talk about that in a moment, I think all 9 justices would overturn it, because I think Smith is a terrible decision that predominantly works to harm religious minorities, right? We see these recent cases playing out in free exercise where the court's creating this new sort of Lukumi Babaluai anti-discrimination principle on steroids, right? But the beneficiaries are predominantly Christian groups, right?
Right.
But the real, and in many cases, mainstream Christian groups, right? But the real harm done by Smith is generally to religious minorities. You mentioned Reynolds v. United States, right? That case today wouldn't even survive the anti-discrimination principle.
Right.
But the whole concept underlying Reynolds was this belief practice dichotomy. Belief is absolutely protected, but practice is not.
Right, and because practice goes into a political space which is shared outside of the temple, the holy ground, or the ceremony, but that belief is not, right? And
that was the argument.
That eroded.
Yeah, that was the argument. The argument was, belief is internal, so but practice, But I think if you look at Smith's version of that, which is even in a way more, well, Reynolds is so disturbing, it's hard to say Smith is more disturbing, But it's very disturbing because by the time we get to Smith, now, you know, the role of religious minorities in society is much clearer. There's many more religious minorities. Reynolds is a case of just in-your-face discrimination.
Right.
Smith is, I mean, the results in Smith are terrible. But Smith, you know, the state in Smith, you read the briefs in Smith, right? And nobody argued to the court that they should get rid of the compelling interest test. They just argued that the state could meet the compelling interest test.
Right.
No, and Justice O'Connor agreed with the state on that. I disagree. I don't think the state could meet the compelling interest test there, but but the reality is the court just went in a completely different direction and reinstated this belief practice dichotomy.
But you have just unmasked the elephant in the room that you have mentioned on several occasions. So now it's time to confront it. And that is Hobby Lobby. Indeed, if one finds Reynolds contemporaneously abhorrent, and I do not necessarily share that view, given the possibility of a plausible alternative view of the nature and necessity of common political space. But that's a conversation we're going to have later. But so stay tuned, folks, for our next video. Right? But Hobby Lobby is Reynolds as well. And if in fact one gets rid of Smith, but one does not confront Hobby Lobby, now you have in your face the implementation, the operationalization of the fear of Reynolds, which is in fact religion now displacing and occupying the public space, not political or religious, but effectively displacing the public space with religious space and everything from mundane economic activity to everything else. And we saw iterations of this in the Masterpiece Cake case and others, and there will be more coming down. So what do you see this relationship between this old conflicting line of cases, right, Smith and Hobby Lobby?
Well, this is interesting, and I think one thing that we probably do disagree on a bit is that I am a fan of overturning Smith as a general matter. However, Hobby Lobby, to me, there's two things going on. One is exactly what you're talking about, which is, these companies were denying a benefit to people that was required by law, right? And so, under Smith, this was for those of you who are unfamiliar, Hobby Lobby was a case under the Religious Freedom Restoration Act. So right. We weren't analyzing it under constitutional law. The court wasn't doing that, but assuming it were a constitutional case, Hobby Lobby would be exactly what you're talking about, right? We have a situation there where these companies were denying a benefit that the government mandated. And I've written about this quite a bit, my concern with Hobby Lobby is not the fact that religious exemptions might be granted. It's that religious exemptions were granted to for-profit entities in the market. And so to me, Hobby Lobby is the worst of both worlds. Right. So on the one hand, Hobby Lobby is terrible for those who work for companies that then assert a religious right to deny benefits or to maybe discriminate in other ways, right? And Hobby Lobby opens that door up under the federal RFRA. That could be dealt with by amending RFRA to define persons to not include for-profit entities, but currently that seems very unlikely. States can do that with their own RFRAs. But in many states, that's unlikely. So the concern, on the one hand, it can lead to a lot of this in the public space, as you're suggesting, people being treated poorly, worse than that, being denied things they are otherwise entitled to based on a market participant's religion. With that said, I think the reason I think it's the worst of both worlds is I think Hobby Lobby also works to harm religious freedom for traditional religious entities. And so I have less problem with Catholic social services discriminating so long as they do refer to other agencies and other agencies are available, because they're a religious entity, right? And even if it was for their own employees, if you go to work for Catholic Social Services, chances are there is going to be some religious element to that. You may know that about a corporation, you may not know that about a for-profit corporation. But what we've seen at the state level, where states have included for-profits, is that states are interpreting their Religious Freedom Restoration Acts more narrowly, even when they apply to traditional religious entities, because they're afraid that they'll be interpreted broadly for for-profit corporations. And I think we see in the background in Fulton a similar phenomenon. I think without Hobby Lobby, without the fear that Smith might get overturned, and then Hobby Lobby might get constitutionalized. Think about Citizens United. And so now we constitutionalize Hobby Lobby, so you can't just amend RFRA to get rid of it. I think that means that Justices Kagan, Sotomayor, maybe even Breyer,
and Roberts, probably.
And Roberts, perhaps. I think that there is Hobby Lobby is like this lurking monster that you can agree with it or disagree with it.
Right.
But what we know is that it actually has harmed religious freedom for traditional religious entities, at least at the state level in some cases, where states have followed it. But again, I think Fulton, without Hobby Lobby, Roberts wanted a 9-0. Right. This is a culture war case. He wanted a 9-0. He could get a 9-0 without overturning Smith, but with overturning Smith, at the very least, he loses probably Sotomayor and Kagan. The Hobby Lobby, I think, is a big reason for that. The other thing is,
and in a sense, if you look at this, Hobby Lobby is the mirror reverse of Smith. You've got both of them, the two poles, right, between which jurisprudence is now looking at itself and developing either fear of one or fear of the other, or a desperate need to get rid of one or the other. And that has really changed the nature of the jurisprudence and the discourse.
Absolutely. And in fact, in the middle of those two is this great case, United States v. Lee, decided in the 1980s, which the Hobby Lobby court heavily misportrays. And you see that when you look at the dissent. But Reynolds, I think if Reynolds had been followed in Hobby Lobby and the court said, well, RFRA, is just really going back to pre-Smith law, Reynolds says, look, in the case, an Amish employer didn't want to pay Social Security taxes because the Amish do. They have a very good social welfare network that does protect people. But the court said, look, you're in the market. You're a for-profit business. You've got to follow the law. It's and the implications, of course, that's very different from a religious individual or entity. And so, that's sort of the perfect balance, which is Smith is wrong. And, the Native Americans in that case should have won. But Hobby Lobby goes too far by including market participants in this, because the market, and I'm certainly not a law and economics person, but the reality is the market is full of public accommodations. It's full of employers so discrimination in the market is something that we have many laws designed to protect against.
And it's also shared social space. And the problem is in a democratic republic like ours, in the absence of shared social spaces, even with accommodation running, either permissive or mandatory running all over, in the absence of that, then you may sink the republic for purposes of privileging the marginal additional benefit to religious expression, now essentially inverting, right, relationships between and among religious communities and among religious communities themselves, and the political and societal communities that exist out there. And if we talk about accommodation, and much of our jurisprudence is about accommodation, that accommodation, that meta accommodation, is necessary to some extent as well, although rarely discussed in any of the cases.
Yeah, and we probably part ways a little bit here,
Yeah,
because I view
but that's what makes
accommodation.
this interesting, huh?
This is what makes it fun, right? I view accommodation, and Chris Lund's done some interesting research on this, that sort of statistically shows it in a way. But the majority of accommodation situations are to the benefit of religious minorities. This is why RFRA, despite being so controversial because of the culture war issues, the predominant benefits of federal RFRA and state RFRAs are Native Americans, Muslims, Jews, Hindus, Buddhists, smaller Christian groups. And so, one of the benefits to accommodation, but you're right, it could open a can of worms. And as you pointed out, because it could invade the space, the public space, as Ice Gruber and Sager and Winnie Sullivan have pointed out, is it could just, the line between religion and other things it's unclear, right? But the argument for accommodation is that the majority frequently doesn't consider religious minorities or even know about them when they make these general laws. And so if freedom of religion is something that really matters, and whether people like it or not, there is a free exercise clause in the Constitution. Then we need to be able to give exemptions to, and then this is where Hobby Lobby becomes a problem, blank, right? You and I would say perhaps individuals and religious entities, traditional religious entities, but then Hobby Lobby adds companies, and that can become problematic. But the idea of accommodations, I think, is a good one. It makes sense that Native Americans, if they're in a state that doesn't exempt peyote, should be able to chew peyote if that's part of their tradition.
Right.
You can think of 1,000 cases: a Muslim woman wearing a hijab, or a Jewish man wearing a yarmulke, or a Sikh having a turban. There are many of these situations that come up. The Waksa tea, which I'm probably mispronouncing, but that's a very, very important thing for El Centro, the church that was involved in that case. So to me, exemptions are a good idea, and Smith was wrong, but I will admit to being scared, because Hobby Lobby makes this public space issue that you're talking about much scarier. When people may not like it if a church doesn't want to be open to same-sex couples or whatever, but people understand it's a church, right? Nobody can tell an individual what they should or should not be able to do in that regard, right? But once we start bringing in for-profit companies, now I think you're right. I mean, at that point, all of public space becomes subsumed.
Right, and of course, the reason I'm interjecting this is a shameless plug for the comparative part of the book, where indeed the normative baseline for making this line drawing, which is really what we're talking about in all of these societies, where the discursive baseline is very different. In a substantial number of cases, we wind up in the same place, but because we start in a very different place, especially now given the recent litigation within the European Court of Human Rights, for example, this notion of shared public space in the context of France, which has got its own very specific contextual issues, then produces a very different discourse, which then gets you to potentially a different place. But I'm going to tease you a little bit. So here's my tease. Let's assume that we can get 9-0 and everyone holds their nose and says, well, we don't have to deal, we can figure out a way of containing Hobby Lobby, that you know, we can confine it to statutory interpretations, whatever, we'll figure something out, right? But we all despise Smith. And now we're going to get rid of it. And as Alito said, we're going to go back to the old rule, right? The Sherbert rule. And at this point, I would say, okay, if I remember correctly, under the old rule, it was a very cold day in a very hot demon's domain when a court would actually further or apply the constitutional principle in favor of the minority religion, and indeed going that direction and embracing the old rule, right, will actually be worse for minority religions if you apply the old jurisprudence, right, than under the current system, which means that what Alito is really saying, and here's my tease, is not that he wants to go back to the old rule. What he wants to do is put the old rule's fig leaf around what he wants to do, which is a new rule that is called the old rule, but is really very different.
Well, you know, and for those of you who don't know, Larry was really literally, Professor Backer was literally teasing me because I've written quite a bit about how bad the old rule was for religious minorities, and so you know, this is why I kind of enjoyed the Coney Barrett Breyer Kavanaugh, because it's such an odd array of justices agreeing on this concurrence, because you know, Alito keeps saying he wants to, use the old rule, but we've seen in Alito's jurisprudence quite a bit. We saw it a lot with Scalia, that it's this: I'm not changing the law, I'm not changing the law, I just completely changed the law, I didn't change the law. Kind of thing, right? And we've seen that a decent bit with Alito, particularly in the religious freedom area. I mean, I think Espinoza, it's not an Alito decision, but we've seen it with the current court, right? I mean, you might view in that way, Fulton might be like Trinity Lutheran, right? Like a step in the middle before the big shoe drops in Espinoza, in another part of the free exercise jurisprudence. I think I would say 50%, I agree with you 100%, which is the old rule was terrible for religious minorities at the Supreme Court level.
Right.
But it wasn't bad for religious minorities in the lower courts. Agreed. Religious minorities under the Sherbert-Yoder rule did win, relatively often in the lower courts. But at SCOTUS, yeah, I mean, Step Feldman and Mark Tushnet have both pointed out that that no non-Christian ever won a free exercise case before the United States Supreme Court prior to Smith. Not that it changed after Smith very much. I mean, I guess it depends on how you view Santeria, but my view is that Santeria is at least in the Christian family, right? And but that's the problem, right? Which is it's a syncretized religion, and so what do you do with
in some of its expressions, in some of it not? It's like everything else, it becomes so complicated and so nuanced depending on which community you're looking at within the greater community.
Right, and how much do they base it on the traditional African religions versus, but what's interesting with that is you could argue theoretically that Lukumi Babaluai was the first case. The Santorians were the first case.
Right.
But that was after Smith and in a very different context with intentional discrimination. But, you know, the reality
and also
is,
wait. And also one, because it is worth pointing out that in the Lakumi Babaluaye case, it was actually discrimination among the community of immigrants who came over, who tried to bring the old discriminations from the home country and naturalize it within the United States. So it was weird on a variety, or unique on a variety of levels. So sorry.
That was a history from Cuba that was playing out in South Florida, which is itself fascinating in that case. But it's arguably, you know, but again, post-Smith. Yeah. And so, you know, we should do one on Lukumi, but because that case, first of all, between your background in the history there and my focus on religious minorities, I think it would be a really interesting, fun.
I mean, add it to the list.
I think that's a case neither of us will disagree about anything on. You know?
Yeah, absolutely.
So, but you know, the reality is, I think that we've seen this with the Roberts Court in general. It's baby steps, right? And I think one of the, you know, perhaps, and this is really your point really leads to this very, very nicely, which is perhaps that was one of the reasons Roberts wanted the 9-0, right? It's the first baby step is a 9-0, you know, somewhat similar to Lukumi Babaluaye or even Trinity Lutheran, which was split, but not a huge split. And then you take the next step, which is possibly overturning Smith, but what do we replace it with?
Right.
And, you know, I guess the question is, do we replace it with what the court said before Smith? Or do we replace it with what the court did before Smith, right? Because what the court said in Sherbert and Yoder should have led to victories for the tribes in Ling, the Ling case, you know, for the plaintiff in Bowen v. Roy, in a number of these cases that before Smith, the plaintiffs lost. And it was as, you know, at that time, there were no religious minorities on the court, and it was pretty obvious. Nobody was saying, you know, well, but you're just completely misunderstanding the importance of this. And so, you know, I would think the current court, if they overturn Smith, will go back to what the court said in Sherbert and Yoder, rather than what the court did between Yoder in 1972, I think, and Smith in 1990, which was really, you know, you look at cases like Olon v. Shabazz, Goldman v. Weinberger. I mean, there's just so many cases where the court gave so much deference to government entities for a variety of reasons. Either it was the government's property, like in Ling, although that is itself questionable given history, or context like Goldman and Olon. But the reality is the court, you know, I suspect the court is not going to be very warm to those decisions. So what it might do is say, we're reinstating the Sherbert and Yoder test without any statements about what came after, quote unquote, Sherbert Yoder. And, you know, the way they seem to be operating over the last whatever years, you know, they're likely to cite to a lot of the lower court opinions where religious minorities did win in between Yoder. So, I mean, from my perspective, a system of no mandatory exemptions to generally applicable laws empowers dominant society, whether it be dominant religions or dominant secularism, to disadvantage religious minorities, not necessarily intentionally, simply through not thinking about it. Right. Why should they? Why should they know what this religious minority or that one thinks? The benefit to an actual real Sherbert test it doesn't mean the government automatically loses, right? The religious minority has a right to an exemption, or the religious majority. Look, it could apply to the majority. I'm not saying it wouldn't apply to the majority. It's just the majority is more likely to be thought of when laws are written. So there's already likely to be an exemption for the majority. Maybe there's not. And so they would have that argument as well. But the government could come back and say, and particularly I think in the anti-discrimination context, come back and say, well, we have a reason, and after Fulton, it's clear, for not giving you specific entity an exemption to the anti-discrimination law here. It's not enough to have an interest in anti-discrimination. It's got to be an interest in denying that particular exception. After Fulton, that's abundantly clear. And so, you know, I think that's where it's going to go. But like you said, you know, with the current court, it's just you don't know where Frankenstein's monster is going to go, so to speak.
Well, I got two Frankenstein monsters for you, and then maybe we can end with this for this time. So here's my two Frankenstein monsters for you. First is, if in fact we do exactly what you suggest, and I believe that you are right, and if I were a betting person, although we all know that's a sin, right, I would bet that it would go in the direction that you are positing, and with a substantial amount of which I disagree, but with a lot of caution. So here's my question number one. Is it likely that they will use the opportunity to overturn Smith to constitutionalize the entirety of the jurisprudence of REFRA, and that in fact the new test will sound like Sherbert-Yoder, but will act like the statutory jurisprudence of REFRA, but now constitutionalized? And then the second question is, in a context like this, where we are dealing, where there is heightened at every level of our social organization with principles of anti-discrimination, is the jurisprudence also going to have to necessarily change to reinvigorate anti-discrimination between religion and non-religion? That is, to treat non-religion as some kind of proxy marker for religion that isn't religion.
So yeah, both of these questions are interesting. You know, the first one, you know, that because of Hobby Lobby, that's my fear, right? You know, I do think, you know, if you look at the language in a case like Hobby Lobby, the court said, you know, we're relying very heavily on statutory interpretation here. They even use the Dictionary Act and whatever. But again, you know, it depends, I guess, who writes the opinion. If it's Alito writing the opinion, then, you know, all consistency could theoretically, in a religious freedom case, you know, he's a great writer, you know, but you know, so was Scalia, and sometimes you could get sold the Brooklyn Bridge, right? And so, you know, I think that that is likely to be the direction. And so I do think it may constitutionalize RFRA. And if that includes the sort of approach from RFRA, right. If it was limited to traditional religious entities and individuals, I would really not be too concerned about that, because then essentially that is what Sherbert and Yoder were really suggesting, right? But if it includes the Hobby Lobby, which I think was a misinterpretation of RFRA, first of all, you know, but even going beyond that, then I think we open up a culture war can of worms. And I think you better be careful what you wish for, because as society and demographics change, what we might have is, if we have multiple for-profit entities winning cases involving particularly discrimination, I think what we're going to end up with is eventually, when the demographics are adequate in terms of younger people who may not have the same commitment to religious freedom and so forth as a basis for this, that we may have a constitutional amendment that gets rid of the free exercise clause.
Right.
And I think you've got to be careful what you wish for there if you're I am a supporter of religious freedom, but not for for-profit entities.
And at that point, Scalia's ghost would come back and say, given what you've just described, he'd say, "I told you so. Smith was right."
He might, although
watch politics, right?
I mean, I guess I would say to Scalia's ghost, well, I'd say a lot of things to Scalia's ghost, but I guess I would say to Scalia's ghost, yeah, but this wasn't because Smith was overturned. This was because for-profit entities have been allowed to discriminate based on religion. And we're not even talking about mom and pop shops here. We're talking about big companies like Hobby Lobby.
Right.
They may be closely held, but 13,000 employees.
Right. And what he would respond is, remember that second to the last paragraph of my opinion where I talked to you about the inexorable power of politics and the need to avoid having the political sphere go crazy. Aha, here you go. You've now described what happens when you have the imbalance that I'm trying to, for all of the problems of Smith. And I'm the first to admit that Smith was as flawed a case as one can get, but there was something there. But anyway, so, last words.
Yeah, well, your second question I think is fascinating, and it brings to mind some really cool writings by Lawrence Sager and Christopher Eisgruber, where they were and Winifred Fowler Sullivan, where they're talking about this. Is there a coherent point of demarcation between religion and other philosophies that occupy not necessarily similar places in people's lives, because religion is very diverse in that regard as well. But I don't know. I guess my response to that would be that I think this court would try to cordon that off. I don't think, I think at a metaphysical level, at a very broad level, there really is no Archimedean point of demarcation. There really is no place from outside of a culture or tradition that we can say, this is where religion ends and philosophy that's not religion begins. And I do completely agree with that argument. And I think scholars of religion, many agree with that argument. I mean, but we do have the free exercise clause in the Constitution. And so one doesn't have to be a textualist to say that we might have to create contextual demarcation points, right? And how that looks and how that plays out, I don't know. And I think that that's one of the fascinating points of your question, right? I mean, if we open this, you could view it as a door, as a Pandora's box, depending on where you're coming from. Yeah. Where do we go in the broader debate about now? Okay, so we now have this standard. Okay, but what happens when someone who is claiming a very strong, deeply held humanist philosophy is arguing for the same sort of protection as someone who's within what they claim to be religion? And I again, I think the literature on that is powerful. And in the end, I think I get back to something Douglas Laycock wrote, which is, but in the end, we still do have a free exercise clause. And so, we can't, and he's certainly not a textualist, right? So, it's not just that, well, we have this text, it's that we have this concept, we have this principle. But I guess the answer is, the jury is out on that. I would be less concerned about it if Hobby Lobby never becomes part of the free exercise clause.
Oh, goodness. And there you go. All right. Well, this has been a lot of fun. And I hope to our listeners that it was an enjoyable and perhaps thought-provoking experience. Consider working through the materials that we've prepared for our book. We, of course, Frank and I are just delighted to respond to your questions and inquiries. You can tell that we're both passionate about the issues, and we love to debate them to death, and then resurrect them and debate them again. So please keep them coming. If you got questions, you want to reach out, enjoy the lectures, and hopefully we will be doing more of these over the course of the next several months. So stay tuned.
Thanks. This was fun. This was a blast. I just I hope that you know, neither of us. I didn't put any money on what happens after this. I hope you didn't either. I don't bet.
All right. Thank you again.
See you later.
All right.